child support increase to max guideline levels.
Your Honor, I think what we're here right now is basically guidance to see how you want this to because I know today this isn't a final, more just to see like a roadmap, Your Honor.
All right, but right now, what I see what we had before us in the pleadings was just a suit for modification. The court notes that the father retained counsel, and I think that's Mr. Partney. Is that correct?
Yes, Judge.
And okay, and the court did in the temporary order that we did back in temporary order we did back in February appointed Ms. Kluzak as the ad litem in this matter. So okay, let's. I'll let everybody tell me what's going on and what we're looking at going forward. And I didn't see any counter petition or anything like that from Mr. Partney, but I'll let him tell him what he's asking for in the behalf of his client and what the state wants to try to do here in the ad litem, and we'll figure out. Sounds like it may be a special setting hearing, but I'll after a few minutes here, I guess we'll be able to determine that. So anyway, let me go ahead and get this one on the record and let's see what we got. So let me start the recorder. Anyway, this is Bell County Calls number 245,545-C. This is in the 169th Judicial District Court of Bell County, Texas, and is in the interest of Thompson minor children. Non-custodial party being John Keith Thompson, custodial party being Susan Price. Let me make sure that's the whole petition. Let me make sure there's no name changes. Yes, that's still the same as was filed as the modification. The court will note for the record that the modification in this matter was filed back in last year in October, that both parties have been noticed and served. Mr. Thompson did retain counsel. Mr. Partney, who was present, filed a general answer in this matter. The court will note for the record that both parties, again, like I said, were served, that we've been operating under a temporary order since February, and in that temporary order, I appointed Ms. Allison Kluzak as an ad litem for the children in this case. Let's see, looks like one of them is definitely emancipated, and the other one turned 18 this year?
Yes, back in July.
Okay. All right, and I just need to know whether or not he's still in high school or not. So
So the state understands that basically that one of the children, John Keith Jr. Thompson, is disabled, and the last temporary order found that that he is a disabled adult, and that established current support for that for John Keith Thompson Jr. And basically, Your Honor, I believe that the last time this case was up for hearing, they were discussing whether or not there'd be a guardianship, and the state understands that has changed. The parties are not seeking to do a guardianship. Instead, they're seeking to establish a special needs trust. And there lies a conflict, Your Honor. So the parties would like, I think, basically to zero out child support and have money be sent from Mr. Thompson directly to the special needs trust, or maybe have like the state disbursement unit send it to the special needs trust, Your Honor. But the state position is that that's not allowed by law. State looks at Texas Family Code section 154-302, which states that in a non-4D case, money can be made payable to a special needs trust, but this is a 4D case. And there's also case law that states that the court cannot order the state disbursement unit to remit payment to a third party, including some kind of trust. But I think that's the main issues. And then there's also, Your Honor, for final, whenever this goes up for final, the state will also argue against being assessed court costs, because I believe Mr. Partney's answer asked for the state to pay that, but state's opposed to that based off of Texas Family Code. I think that's it, Your Honor.
all right, Partney.
We're not asking for attorney's fees. Sorry, that was just form language that got added to that. So that's not on the table.
We know how ProDoc. Well, I'm sorry, is it still ProDoc these days, or is something else?
It's another name, but it's still ProDocs.
Okay, good enough. Thank you.
Yes, Your Honor. My name's Jason Partney. I'm here for non-custodial parent John Thompson, the dad. We agree that the younger child here is an adult disabled child. He turned 18. He graduated from school. He still is going to school a few hours a day. They allow that for disabled children, but he has graduated and is over 18. We agree that the child needs some support and is not capable of self-support. When first we came back in February and had the temporary orders, child support increased to max guideline levels. You ordered the guardian ad litem to be appointed and for mom to look into SSDI, SSI for the child. When we came last hearing, mom had gotten word back from Social Security that the child didn't qualify because child is receiving child support. And so the last time we were in court, we were going to look into special needs trusts and guardianships. We have done that. What we have found is the ARC of Texas, that's who the parties would like to go for. It's a special pooled trust for special needs kids and adults. That has 3 different trusts four different trust options, 1, 2, 3, 4. And the parties have selected number 3 because it's got flexibility to use the trust funds for things like food and shelter. 2 of those trusts, you can't do that. You can't use that trust fund for food and shelter for the child. So those are no good. And the other trust number 3 has no payback requirement for Medicaid at the end of this now adult child's life. The other ones, if the child expires, then Medicaid could come back and look to that trust for repayment. Trust 3 does not have that requirement. The trouble is with trust 3 is if there is child support ordered directly through court order, Social Security is going to see that as income. So the parties, everybody agrees, of course, myself, my client, mother, ad litem, all agree that we can non-suit this case or put some language in an order that says there is no child support with the expectation that parents will support the child through the special needs trust. And that will allow them to pay directly to the special needs trust and not have income for the child and not disqualify this child from SSI, from Medicaid, from other big benefits that are far going to outweigh any child support that's coming through. Directly to the statute 154.302, the state is correct. There is one sentence that says this subsection does not apply in Title 40 cases. We could remove this up to the referring court, and that would, I think, solve that issue. So I could file the objection to Your Honor, the associate judge hearing this, but I think
it's got to be a straight out motion to transfer because the objection is way too late. So yeah.
Yeah. And so then the other option is, okay, we de novo at the end of this, and then we're doing it twice, and I don't want to waste the state's resources in that way. So in this statute, it specifically says that if the court has a child with disability, that payment needs to go directly to the special needs trust. The court shall order payable to the special needs trust directly to it and may not order the support to be paid to the state disbursement unit. And so that's where we're getting stuck here, is the state can't agree because their policy says no. But I think the solution here is what all the parties want, is to essentially non-suit this or have an order that says direct child support ordered is terminated, but the parties are ordered to pay through the state through the special needs trust. So that would be our position. And I'll turn it over to Ms. Cusick.
Okay, real quick, we're doing this, we're looking at this because the child's special needs far exceed the amount that the child support recovers. Is that correct?
Is that for me?
Yes, sir. Yeah, Mr. Partney. That's the reasoning for the trust, and that way the other benefits could still be there, and the trust could take care of anything that's supplemental to all those other benefits. Is that the reason we're looking at this, sir?
Yes, for the child to get Medicaid and Social Security, that would outweigh the child support benefits. And not that dad's not going to keep paying something. And we could have a kind of finding in there that we all agree it's adult disabled child. Parties are going to pay directly. Parties acknowledge they can come back and repetition the court if there's ever a problem with these payments. And that might leave the door open to let everyone feel comfortable. We're not closing anything today. And have a problem for shenanigans later that can't be redressed.
Okay. All right, Ms. Cusack.
Judge, I agree with I agree with both attorneys' statements on this. I specifically agree with Mr. Partney's take on it. I think that's in the best interest of Junior. There are substantial therapies that he partakes in that, Ms. Price Cruz needs some assistance with. And so that's the purpose for, this support continuing after 18. He also needs that SSI and Medicaid. I mean, the SSI, of course, is in the big spectrum of things, you know, smaller potatoes than the rest of it, but the Medicaid is very important. And so we've got to figure out how to structure it. And unfortunately, it's just the way SSI is, that he can't have a certain amount of money, or else that will knock him out of these services that he needs. And then, of course, then if he no longer has Medicaid, that's going to drive up the price of all the other things that are covered by Medicaid, which will then just kind of snowball. So I agree that this is something that we need to try to facilitate. The one distinction I'll make from what was said earlier, I believe Ms. Price Cruz plans on doing a guardianship. That's just not a now.
Okay,
Yeah.
that's what I was getting at. Here's the deal, guys. When I got this job, I was looking at taking my board certification in probate because I had about a half a dozen of these cases. And every last one of them, I had, we were doing we did the trust, we did the guardianship, and we were making the annual reports. It was always, I said, this was a lot easier and a lot more fun than family law. Okay, so I was gonna walk away from family law to a great extent and do this, because I love doing that type of work. And like I said, at the time I closed my practice, I had at least somewhere between 4 and 6 of these cases. So I understand everything was going that you were saying, but that guardianship part, I was thinking that it's going to be something that's going to have to be eventually taken care of. Otherwise, this will probably not fly. So so anyway, I know exactly what you're talking about. So go ahead and proceed, but I'm probably looking at whether or not the state may need to get out of this one way or the other. I'm also going to look at calling up the DJ and see about transferring this over to them and let them take care of this. That way it can all be taken care of in one swell swoop. But again, you're probably looking at Ms. Price Cruz. Definitely, still will probably have to do that guardianship, because I don't think there's any way around that. Because right now, this child, he's an adult, and she doesn't have any rights to tell him what to do. So yeah, she's got the right to manage the monies that come in from child support, but she can't tell without that guardianship over the person in the estate. Yeah, that's going to be problematic. So yeah, and at least the estate part probably needs to take place. So yeah.
Yes, Judge. I'll let you know that from what Ms. Price Cruz mentioned earlier, she has looked into that and she does plan to do that. But as far as focusing money on retainers to hire people, the first goal is to get this special needs trust set up, and then she does plan on doing a guardianship when she can afford that retainer. So that is in the works, but it's just not a now thing. Currently, she has a power of attorney, which of course lets her take care of some business. Although, as you pointed out, if the child says, I don't want to, then that defeats the power of attorney. So the guardianship will have to be done eventually, and it's in the works. It's just not a today thing.
All right, then. Anything else, Ms. Cusack?
No, Your Honor. I agree with what you stated about possibly removing it. Not that I think it would be great if you could handle that, but I think that sentence on the 4D sentence at the end of that paragraph that Mr. Partney read, I think that precludes what we're trying to get done. So I think the only venue is to take it out of the 4D realm.
All right, then. Again, none of my cases I ever dealt with 4D. So I had trust already set up, and they were what they were. So again, this is the first time it's ever been brought to the court's attention about that 4D portion, and so I'm going to have to take a look at it, and I might even give Tammy a call up, see if she ever ran into something like that in 30 years she was doing this job, see how they tried to handle it. But anyway, Mr. Welch, anything else? With the court having to obviously look at doing a reset, getting in touch with the district court to see how they might want to try to handle this. They might be a little bit more up to date on this. Like I said, I used to do this. I used to do it a lot, but that was 15, 20 years ago. So, okay, and I'm pretty sure things have changed a little bit. So anyway, Mr. Welch, anything else the state wants to make on the court of before I do a reset to see about possible transfer after I talk to the district judge, okay? Because if the district judge wants to take it, then I'll probably make the transfer on my own motion, all right?
Yes, Your Honor. I did want, just wanted to make sure, yeah, the state can't agree to non-suit because it's our suit for modification.
Yeah, I
Um,
know, I know. Yeah.
And
But
also,
again, and I'm not sure how, yeah. Go ahead, sir.
it's just I also wanted to reiterate on or to address some things. First of all, that only the the Texas Supreme Court can order us to change the payee. And also that child support
Well, I'm
isn't.
sorry, you cracked up on me. What was that? Repeat what you just said. You cracked up on me. Thank you.
Oh, yes, Your Honor. So I just wanted to make sure the court knew that, only the Texas Supreme Court can order us to change who the payee will be. And also, Your Honor, child support isn't income for the child. And I don't think the child's disability will interfere with the child's Medicaid eligibility. I just want to make sure the court knew that. And I agree, Your Honor, that I think we're too late for an objection to associate judge. If the court wants to transfer this to district court, then that's up to the court's discretion, I guess.
All right, judges. Okay. All right, Mr. Pardon, anything else, sir?
Not for me, sir.
All right. Again, see, I'm trying to remember all this stuff from 20 years ago, and it's there's a lot of cobwebs up there, and because I had when we set up the trust, I had cases where there was already a trust, but the trust wasn't covering the expenses, so we had to set up another trust. Yeah, oh man, that was a fun one. So, all right, well let me talk to the district court and see how we're going to set this up. I'll tell you what, guys, let's go ahead and do a reset on a special setting where I can get an update from everybody. I'm gonna do this on a Wednesday, Ms. Cusack, so you can appear. And I think I got a date in the next couple of weeks that I didn't know about that we might be able to come in and get an update, and that'll give me a chance also to refresh my memory, see what and check out the statutes that were just quoted. Because again, Mr. Welch, in none of my cases was the state attorney general's office child support division involved. It was always private circumstances. So that probably made it a little bit less cumbersome and a little bit more straightforward. But anyway, let's do a reset and see if we can get everybody back in here and see what the circumstances are. And again, Ms. Cusack and Ms. Price Cruz, I know. Believe me, when I was doing that in 2001, I was charging $250 an hour back in those days, and that was 20 years ago. So I can't imagine what lawyers are charging these days, but it's something that may have to be done as far as that guardianship is concerned. Because when I did it, we set up everything. We set up the trust, we set up the guardianship, and that way. Because Judge Johnson would not take it any other way. And I know I'm not sure if Ms. Cusack was around for Ed, but I know Mr. Partney probably wasn't. But yeah, when you came in to see Ed about that, you better have your I's dotted and your T's crossed because he wasn't playing. So, all right, I sure missed that man, but he was definitely a stickler for everything being in order. So let's see what I got here.
That's what I heard that as well, Judge. He was by the books, which is good. But I didn't practice in his court though.
Okay. Well, his big thing was that the judge that oversaw guardianships could be personally liable for things under that something went wrong. So he actually could be sued for that. So personally,
wow,
he said that. I never looked it up because I took his word for it, but I'm going, yeah, I would kind of want to dot my I's and cross my T's if they're going to come take my house from me, okay? So, yeah. Let's see, what do I have here? I've got a 1:30 to 2:30 slot available. 3:30, I got a 1:30 to 3:30 slot available on Wednesday, the 25th of September. If we can get an update, and y'all will be the only ones at that 1:30 slot, so I think it'd be less than an hour. So I'll give y'all 1:30 to 2:30, or even 1:30 to 3:30 if necessary. But I have that slot available, and that's the quickest one I have. But it'll give me a chance to talk to the DJ. And who's the probate judge now in county? Who does those cases now?
Is it Judge Parker?
Okay. All right, we're not gonna always get
Wait, no, she's county court. No, yeah, I think she Judge
she's still doing it.
Judge Jeannie Parker.
Yeah, okay, she's still doing them, okay, yeah, because she did our probate, my dad's probate, so yeah, okay, got it. All right, here we go. Oh, wow, that document.
Judge, actually, the
Okay, well,
25th, I have appointments. I had to reschedule for something else. I don't know if there's anything available on the 9th of October.
all right, here's the deal, folks. That's the day, that's the week I'm doing advanced family, but I can sneak an hour here again at my no. There's a lunch break at that. Okay, that's a live video and they have a lunch break, so I can do 12 noon on that date for an
I could do
hour.
that,
No
but I
problem.
could also do the 16th or 17th. I don't want the court to have to double. I don't want to impose on time where you're doing other things just because of my schedule. I can move things around.
I can pause it, okay? Not a problem, all right? So I can look and go ahead and do a special setting at 12 noon on the 9th. Mr. Partner, can you be available for that, sir?
Yes, sir. That's fine with me.
Okay. All right, let me go ahead and make a Zoom code for that. Again, by then, I'm going to be tired of listening to all those lawyers tell me what I should know about in family law in a non-legislative year. But there won't be a problem me taking an hour break, and I'll just send out for DoorDash. All right, so we're good. All right, then, folks. Let's go ahead and get an update on that date. And like I said, give me a chance to read up on this and see what we may be looking at. And I will talk to the district judge, and if I think it's necessary, I'll give Judge Parker a call and see what she likes, and we'll take it from there. So October 9th, 12 noon straight up, and I'll go ahead and make the Zoom code as soon as we get through. So I'll go back among the lawyers, and then I'll go. I'm sorry, I'm going to start with you, Miss Bryce Cruz. We just do a lot of legal mumbo jumbo out at you, and so believe me, man, some of this stuff is the most complicated stuff I ever did as a lawyer. Because it's very, very complicated. So at this time, ma'am, what questions do you have?
I don't have anything right now.
All right. Mr. Welch, anything else on your end, sir?
No, Your Honor, I'll have the reset order sent to DocuSign to the parties.
And I'll get y'all code within the next 15 minutes or so, so you can be able to put that in there. Anything else then?
No, Your Honor, thank you.
All right, Mr. Partney.
Nothing for me, Judge.
Ms. Kuzak.
Judge.
All right, thank y'all all very much, and we'll go ahead and like I said, I'll make that Zoom code, and you just start reminding me what it might have been if I had not I'm a judge. All right, so yeah, I guarantee you I would know this one down pat by now. So yeah. So anyway, thank y'all all very much, and we're off the record, and I'm gonna go ahead and make the Zoom code. Mr. Welch, and Ms. Walker, I'm gonna take about a 15-minute break, and then I'll come back and work to lunchtime. Okay, thank you. All right, see everybody in a couple of weeks. We're off the record.
The indefinite child support was set without my knowledge or my consent. And by the time I found out about it, I was being asked to sign the paperwork in front of the judge. I wasn't given any information from the attorney general or either my ex-wife as to why it was set for indefinite child support. And from my understanding, the reason why they haven't is because there is no paperwork. Was that she wasn't able to give me that because there was no actual paperwork. That was something that the attorney general had decided. So I'm trying to figure out, how does the attorney general come to the determination that a child is medically unable to without a medical dossier or a medical examination, and then just determine that I'm on indefinite child support?